Morning people, we are discussing about the polity section. Polity section, the August static static keys. Let us discuss the first question of today, that is related to the polity, and that is related to the Government of India Act of 1858. Government of India 1858, why it news में तो नहीं था, but yes, why it be so important? Government of India Act gave the complete authority of the crown on India, but in 1876 it became the real princes of India. But yes, the whole East India Company power is gone there in itself, and here it made the Secretary of State that lies in the House of Lords in Britain Parliament, right? And what type of rules and regulation that is giving it give the Indianization of military, and it decreases the proportion of itself lying the military. It means the 50% is the main presidency, for example Madras and Madras, Bombay, and then third is the Bengal it is 50-50, Madras 40-50, and Bombay also 40:60. Let us see the question. It abolished the East India Company rule in India. Is it right? Number second, it changed the entire structure government in India prevailing earlier. Is it right? It changed the entire structure of government in India that prevailing earlier, because earlier what is it? Court of director, court of control. Yes. Number third, as per the act, Indian government was to be supervised and controlled in India. Is it right? Because Secretary of State is there. So I think second is तीनों के तीनों ही सही होना चाहिए. Second is wrong. Why? It changed the entire structure of India prevailing earlier. I think that is right. Don't know why it is wrong. If I am in the exam, I just corrected. It abolished the East India Company. That is right. As per the act, Indian government was to supervise and control in England. Yes, it is right, because of the Secretary of State that lies there. But yes, earlier changes system. Whole तो नहीं, complete entire structure तो नहीं. But yes, some structure that of working in India is changes in Government of India Act of 1858. Let us see the explanation. The Signify Act was enacted in the wake of the revolt of 1857. Why it be so? Why there is the Government of India Act of 1858? Earlier there is a charter, but here is the Government of India Act. Why? Because of the mutiny of 1857, the first independence act of 1857, which is said by the Veer Savarkar. The act was as the act for the good government. Why it be so? Because they wanted to be governed in a better way. Good government of India. Abolish the East India Company here. Abolish the East India Company. Okay. The mutiny that we are facing, that is the mutiny of people of India versus East India Company. So it is not the case here. And transfer the government of India, territory and revenue of the British Crown. Next is power. What is the power or the feature of that act? It established a henceforth has to govern in terms of the His Majesty. It means that the name of the crown is signifying here. It changed the designation of Governor General of India. It means the Governor General is now called the Viceroy of India. It ended the system of double government that abolished the board of control. Yes, board of control and the court of director is abolished here. It created new office, that is the Secretary of State, vested with the complete authority and control over Indian administration. It has the main power of rather than a viceroy. It means that the signal of main authority in India is the Secretary of State rather than Viceroy, in which we are very much of critical. That is not the Viceroy, but we are not having that thing. Anyway, abolish the Board of Control and the Board of Directors. Secretary of State was with the complete authority and control over India. The Secretary of State was a member of the British Cabinet. It means that is a member of the British Cabinet and was responsible for ultimately to the British Parliament. It established a cabinet. It means the cabinet hai, that is the part of the House of the Lord, House of Commons, in which the government of the day is changing or the ruling. It established a 15-member Council of India to assist the Secretary of State for India. It means the council is made here, and that is under the Secretary of State that lies in the British Parliament. The council was an advisory body. Yes, we are all right. The Secretary of State was made a chairman of the council. It constitutes the Secretary of State in council is a body corporate capable of suing and being issued in India and England both. Next is the Act of 1858 was, however, largely confined to the improvement of the administration machinery by which the Indian government was to be supervised, in which it means that it means the government of Britain just wanted to improve the administrative machinery, not over the in which the structure they are East India Company is ruling and control in India. It did not alter in any substantially any government that prevalent in India. Next question is about the which of the following, what we have learned from that thing. That means court of director and court of control, board of control and the court of director is abolished here. Number second thing, Secretary of State that is responsible for the British Parliament is confined here. Number third, the 15 Council of Ministers is added here, and designation of the Governor General is changing here. and whole a lot of structure that earlier present is completely here, because Dalhousie make effort so to unite India, in which many of the earlier attempt to codify the laws and the administration machinery to come in the East India Company is already taken there. There is no much of substance that they are be correcting, right? Next question, for example, if you are considering military power and the army, police, already they are considered, then they are be major reason, so that the already that are taken place. There is no much more of to British Parliament in which they can changes in India. Which of the following parliamentary system are not chaired by the speaker? Okay, in which of the following parliamentary committee in which the speaker are not the chair? Number first, public account committee. ओके लेट अस सी, मैं एक बार बता दे रही हूँ. स्पीकर की पावर के बारे में बात करें तो इट मेक द बिजनेस conduct of the business in parliament, or in case of the Rajya Sabha it is the chairman, and in case of the Lok Sabha it is the speaker. That is the case. And all the financial parliamentary committee is appointed by the speaker, and it is not the speaker who made the member of all the parliamentary finance committee. Included three main committee. First is the estimate committee, number second is the public account committee, number third is I forgot the name, and estimate committee, and yes, committee on public undertaking, that is related to the finance. So ये three committee का ये chair not chaired by, yes. Public account committee is not chaired by, yes, सही है. Business advisory committee, let us see, that is chaired by the speaker itself. So estimate committee, yes. Rules committee, that is chaired by the speaker itself. And committee on public undertaking, so first, third and fifth. First, third and fifth, I think B is the correct statement here. The speaker appoints the chairman of all the parliamentary committee of the Lok Sabha and supervise their functioning. It means that it has the functionary role of the supervision. He himself is the chairman of the business advisory committee, because it is the business of the Lok Sabha in which how the member of parliament is conducted in that case. And the second, the rules committee, rules that is related to the parliament, how it be the generated in the course in Lok Sabha itself. Next is general purpose committee, that is the general purpose, that is the main headache of the speaker. Next question is about the election commission can take against the candidate and the political party. Okay, that is the relation between the election commission. What can be the power of the election commission regarding the political party? Okay, now first function that his election commission is done the registration of the political party. Number first is the registration of a political party. Number second function, that is it cannot deregulate the derecognized the member of parliament. It has the recognized or deregister the political party if the following criteria is not met by the political party itself. So it has the power, right? Number third power is related to the election commission is that when the parliament MP or MLA case is gone to the high court, then the recommendation of the election commission is made mandatory here, and it is not applicable to the Supreme Court. But whenever the president taking the recommendation from the election commission, yes, it is mandatory for election president that it sue or it listen or it whatever the advisory or the recommendation given by election commission of India, it should be implemented. So it is the binding on the president. Do you remember the fact? Let us see the what type of question is there. Number first statement is about the election commission cannot be bar candidate or a leader from campaigning for a specialized period. It means the election commission cannot be bar candidate or a leader from campaigning for a specified period. Okay, number second, election commission monitor the adherence of a political party and candidate to the model code of conduct. It means that it oversees the model code of conduct. Is it right? Number third, it can be postpone election of any constituency, cancel an election already notified, but cannot abrogate or annul election already held. आपको बताना पहली बात तो इनकरेक्ट. Number third statement, let us see again, read it. It can postpone. It means it can postpone the election of any constituency in which the election will be held, and cancel an election or it can cancel the election. For example, if a national emergency is taken or the unhaphazard condition that the law and order condition is not enough to held the election, in which the election already be cancelled by the election commission of India. Number third, but cannot abrogate or annul जो election हो चुका है, that cannot be abrogated. I think that is right. Third is right. Number second, election commission monitor the adherence of political party, that is right. Number first, election commission cannot bar candidate or नहीं, it is not the barring of the candidate. Let us see. We already saw कि it can recognize or deregister or register the political party, but not the candidate. Candidate पे ज़्यादा power नहीं है, and whole of the political party is governed according to the RP Act of 1951, and delimitation is per the 1950 RP Act of 1950, and voter age and etc. That is the part of the RP Act of 1950. Let us see. What are the possible action election commission can take against the candidate and the parties? Election commission monitor the adherence of a political party and candidate to the model code of conduct. If the violations are also offensed under election law and the criminal law of the land, election commission has the power to recommend or register party which we are earlier being, but it means the first and third is right. I think may have the third is third is also right, because it can be annulled by just Supreme Court. That is not the power, or the suo motu not the power of the इलेक्शन कमीशन. बट येस, अगर सो मोटो नहीं है तो कोई और जाके वहाँ पे PIL वगैरह डाले तो हो सकते हैं. एनी वे लेट अस सी. इलेक्शन कमीशन वुड मीन्स दैट येस इन नॉर्मल सर्कमस्टांसेस येस इट इज राइट, सी इज रॉन्ग. एनी वे, however, for some violations such as canvassing for a voter during a period when electioneering is barred, making official monument announcement while the MC is in force, and making appeal to the voter on selection ground, the election commission has the power to advise or censor candidate in addition to directing registration of cases. It means that it has the power in case of the model code of conduct, never it else. In some cases, a recent incident would show election commission may bar candidate or a leader from the campaigning for a specified period. That is the case, yes. Asking individual to leave a constituency, barring entry into certain area, or other power that election commission may exercise. These powers are not necessarily traceable to any provision in law, but generally considered as the responsibility as per the constitution that is given to the election commission. It powers extended to postpone election to any constituency, cancelling an election already taken place, even to abrogate or already. But it is not the suo motu power of the election commission. Let us see the next question that is related to the whip. Office of whip, we already see it is not given in the rule of conduct or business conduct में कहीं पे नहीं दिया गया. It is the convention that in which the whip is happened. Okay, about the whip, and it is the just related to the political party, and it take work in the it is can be 2 or 3 type, and it is the up to the third type in which the member of parliament are to be present there, not in all other cases. Number third, in which if whip can be issued, then 15 days notice can be given by the member of parliament कि वे attend कर सकता. For example, severe injury अगर आई है that he could not attend, that has the latency that is given in the whip. और whip के regarding, okay, anyway, let us discuss. The office has been established by rule of business in each house of the parliament. Is it right? Number second, only the ruling party is allowed to have a whip in each house of parliament. Is it right? Both is incorrect. Office of whip is mentioned neither in the Constitution of India nor the rule book of the House nor the parliamentary statute is given to the whip. Political party has the power, whether ruling or opposition, both has the power of issuing the whip. He is appointed by the political party to serve as the assistant floor leader. He is charged with the responsibility of ensuring the attendance of his party member in large number and securing their support in favor against a particular issue. It means that it is the ideology of the party. He regulates and monitors their behavior in the parliament. Their members are supposed to follow the directive that is given by the whip, otherwise disciplinary action can be taken against that member also, and it can be the reason for the disqualification of that member itself. Next question is about the constitution lays down which of the following condition for the governor, office of the governor, selection to the governor office. Okay, constitution, what is the constitution is given, what is the governor, who is governor, कौन बन सकता है governor? Governor कोई भी हो सकता है, but his age is about 35 years. And number second person, he is the jurist in the right person in the eye of the president, and he is the citizen of India. Second thing, only these things are given in the constitution. Let us see. Number first में the governor should not belong to the state where he is appointed. No, it is the convention कि cooling period होना चाहिए, और ये सरकारी कमीशन की रिकमेंडेशन के हिसाब से है. Number second, the governor appointed must be made after consulting the chief minister of the state. That is a case of ideal situation, but that never happened in India, or happened in a very much less period of time in which that is not significant at all. Number third, a serving governor cannot be member of either house of parliament or a house of the state legislature. A serving governor cannot be member of the either house of parliament or a member, yes, because it is the office of profit. He should not hold any profit of office in the central government or the state government. Yes, that is right. Which of the following are correct? That is the condition also. That is also given in the constitution, right? We are asking the B answer is the only third is correct. Let us see. Article 157 and Article 150 of the constitution, India specify requirement the post of the governor. Let us see. Should be a citizen, complete the age of 35 years, not be a member of either house of the parliament, and it is not hold office any profit of office, right? Additionally, two convention have developed over the year. Number first, he should be outsider, and it should be have the cooling period in the period if whatever position already in the past he already held, and state will is appointed so that there is a free from the local politics. Second, while appointing the governor, the president is required to consult the chief minister of the state concerned so that the smooth functioning of the constitutional machinery in the state is ensured. Both the controversy have been avoided in some of the cases. That's why it has always been used, otherwise not at all. Next question is about the following statement regarding the first Lok Sabha met on the eve of the first Republic Day. Is it right? First Republic Day is when happened? When 26th January 1950. If you are forgetting that date, it is not good for you. Okay, पहली बात तो हम लोकसभा की बात करें. That existed in 1952. Election 1951 में अक्टूबर में स्टार्ट हो गए थे. रिजल्ट 1952 तक आया था. एंड जब ये सब हो रहा था तो हमारी इलेक्शन कमीशन ऑफ इंडिया ने एक चीज़ ऑब्जर्व की थी कि द वुमेन पार्टिसिपेशन इज़ क्वाइट गुड एज एक्सपेक्टेड, बट problem is that there is not a original name. Original name, but it means that it has the backup of any person or the male member of the house. So that's why it has to be much more number कि उनको डी-रजिस्टर करना, डी-नोटिफाई करना पड़ा था from the voter list. India ceased to be a British dominion immediately post enacted of the constitution. Number second, India ceased to be British dominion. इट मीन ख़त्म हो जाना इंडिया ब्रिटिश सीज टू ब्रिटिश डोमिनियन जब हमने अपना पोस्ट जब कॉन्स्टिट्यूशन को इनेक्ट कर लिया. क्या ये सही? आई थिंक दैट इज़ राइट. इमीडिएटली यस. तो फर्स्ट इज़ इनकरेक्ट. फर्स्ट इज़ इनकरेक्ट. यस, बिल्कुल इनकरेक्ट है क्योंकि इट इज़ अंडर 1952 में ये सब हुआ था. नोट द फर्स्ट. एंड दैट फर्स्ट मीटिंग जब हुई थी 26 जनवरी 1950 में हो गया था. तो फर्स्ट इज़ रॉन्ग. एंड इंडिया सीज टू बी द ब्रिटिश डोमिनियन इमीडिएटली. दैट इज़ राइट बिकॉज द पोस्ट इनेक्टमेंट of the constitution given in the constitution itself we could not become the dominion. It means that Indian Independence Act of 1947 is annulled by the constitution itself. So answer is here is A. Let us see what are the explanation is given in the inside. Now first Lok Sabha met in 1952 under J.V. Mavlankar. Is it right? Yes, sahi hai. Okay, it is very simple information, not so important. The Indian Independence Act of 1947 merely converted India into British dominion. It ceased to be dominion only after the 26th January 1950s. Number third, till 1950 the constitution assembly itself act as the law making body. So it is not necessary कि अगर मान ले हम 1956 में करते तो इसका मतलब ये नहीं था कि सेंटर पे कोई गवर्नमेंट नहीं. गवर्नमेंट काम कर रही थी, इवन प्रॉपर मशीनरी थी हमारे पास में. That is the advantage we are taken from as compared to the Pakistan where is not so much of development. Number four, Lok Sabha was duly Lok Sabha we are meeting on the 17th April 1952 after the first general election. Next question is about the National Commission for ST with respect to the general protection and the welfare of ST. Okay, ST office earlier it is the not in the constitution. It is added as per the constitutional amendment. I forget the constitutional amendment. I think 89th constitutional amendment जहाँ तक मुझे याद आ रहा है. But in 2004 it bifurcated between the SC and ST. 1978 में एक resolution लेकर आया गया था regarding the SC office and ST office, but in I think 1988 it gave the proper statutory status, but it is the SC and ST both. But in 2004 it bifurcated and make the constitutional amendment, and it added 338A, 338B, sorry 338A, that is the SC, 338A that is the ST. Let us see. And what is the function of the SC and ST is नंबर फर्स्ट कि ट्राइबल एरिया को देखना, ट्राइबल एरिया उनका डेवलपमेंट करना, उनसे रिलेटेड कोई भी प्रॉब्लम है उनकी जो रिपोर्ट है वो प्रेसिडेंट को सबमिट करना. नंबर फोर्थ में इनसे रिलेटेड जो भी झूमिंग वगैरह वो करते हैं. फॉर एग्जांपल मिजोरम में बहुत ज़्यादा झूमिंग होती है. मीन 60% ऑफ द पीपल इज रिलेटेड टू द झूमिंग कल्टिवेशन दे आर डोन इन टुडे ऑल्सो. सो इनको कम करना एंड मशीनरी एंड सब्सिस्टेंस प्रोवाइड करना टू द ट्राइबल पीपल. दैट इज द फंक्शन ऑफ द ST. लेट अस सी द क्वेश्चन. Measure to be taken over the conferring ownership right to the respect of the minor forest produce to ST living in forest area. It means the measures should be taken regarding the ownership right in respect of the minor forest produce if they are residing in the forest area. Number second, it measure to be taken to promote the traditional practice of the shifting. It measure to be promoted. Is it making the promotion? Number third, measure to be taken to safeguard right of the tribal communities over the water resources. What is the question? Yes, third is right. Second is completely wrong. Second, if you can cut, the answer is first and third. So C is the answer. Measure to be taken in conferring the right of the ownership. Okay, that is the Forest Right Act of 2006 given right to the tribal area where the some specific date is mentioned. That is like, for example, if the people 75% of the 75 year ago they are living residing there, from the date is 2006 itself. And number second, their subsistence is dependent of the on the tribal or the forest. Number third, the condition is that the hectare limit or the ceiling is there 4 hectare. The land is not above the 4 hectare that can be issued to the tribal people or their forestry side. And number fourth, the power to the Gram Sabha is given. If I am the forest dweller and I am living from 75 years or the prescribed limit that are given in the act itself, if that is there, the whole case given to the Gram Sabha, that is taken into the consideration whether he is there or not. That is the limitation of that act, and that is given to the state central government. Yes, right. So here first and third is correct. Let us see the explanation of the inside. In 2005, the President specified the following function of the Commission in relation to the promotion, welfare and development of the development and advancement of the STs. Measure to be taken out the conflict ownership right in respect of the minor forest produce to the ST people living there. Number second, measure to be taken to safeguard right of the tribal communities over mineral resources, water resources as per the law, but as per the law itself. Measure to be taken development of tribal people livelihood condition ताकि subsistence basis से आके उनका development हो. Number four, measure to be taken to improve the efficiency of the relief and the rehabilitation. Measure to be tribal group and displaced people. Measure to be taken or prevent alienation of tribal people from the land and effectively to rehabilitate the people in whose case alienation has taken place. Measure to be taken to the maximum corporation and involvement of tribal people as much as possible so that the policy formulation they can be included. Measure to be taken to ensure full implementation of the provision of the panchayat that is extended to that area, that is the Peace Act of 1996. Measure to be taken reduce and ultimately elimination of the practice of the shifting cultivation. Yes, we have to make because we have the very less forest cover, that is I think 24.54, and that is not only the desert forest and also the forest cover. Forest cover is the private owned land. After the forest is not there, but in the nearby the plant of roads etc. that is the count in the forest cover, and it is a report also came. Okay? Let's discuss the next question that is related to the CAG. CAG is given in the office and it is one of the watchdog, and the CAG is appointed under seal and the warrant of the president itself, and it is given in the article 148 of the constitution, and its power is given into 149 of the constitution. And why is in news? Because of the redaction activity. First time I think Minister of Finance redact one of the provision of the Rafale deal, that is in very much of news. But अगर ऐसा पूछा गया कि what is type of question is from the CAG is expected of today is year मतलब this year, sorry, that is the redaction how it can be happened, but it is related to the CAG activity, that is the blackened some of the unit and the figure in the report is blackened by the ministry, so that the parliament cannot be questioned that thing, and the whole information that is of the security nature that cannot come into the public. And let us see, and okay, who appointed it? President. And public account committee is related to the CAG only because the president CAG make the report, that is gone to the president given to the parliament report is just discussed it and then given to public account committee to the scrutiny, and it is called, the CAG is called the philosopher of the public account committee, guardian or philosopher, whatever the case would be. And in 1973 CAG office of comptroller, that is the accountant general of India, is completely abolished from there. उनसे पावर ये छीन ली गई कि यूनियन का वो कंप्यूटर नहीं बनेगा, जो भी डे टू डेली एक्टिविटी अकाउंटेंट की होती है that should not taken from the CAG, but in case of the state it should be intact with the CAG. It means that the CAG has the authority of the account of the state but not the union, but it power is taken from the 1970s. I think the 42nd constitutional amendment is there right now. Let us see. Consider the following statement regarding financial and accountability of legislature to the executive. Legislature is in which? Parliament. Parliament is in whom? Lok Sabha or Rajya Sabha, that is making the parliament or the legislature, because legislature includes Lok Sabha and Rajya Sabha, and if president give the assent, that become the parliament whole. To the executive, note first, CAG submit audit report to the president, is it right? CAG submit, again read it, CAG submit report to the president, is it right? Number second, public account committee examine CAG report. Number 3, Public Account Committee submit the audit report of CAG to the President after due examination. कौन से बताना है correct है? First and second is correct. It means C answer is there. How the CAG 3 report given to the President. Number first is the audit report on the appropriation account. It means the appropriated account. Whatever the amount is appropriated or the bill is appropriated by the Parliament, the audit report of that appropriation is given to the President by the CAG. Number second, audit report on the finance account, whatever the finance account in which the appropriation or the implementation of any of the related to the finance is given. Number third, audit report on the public undertaking, that is related to the public undertaking of the center of the state, whatever the case. The President lays this report to the House of the Parliament. After this, a public account committee examine, मतलब it means the House of the Parliament में टेबल किया जाता है और उस पर डिस्कस होता है. दैट द गुड थिंग नहीं होता है तो दैट गिवन टू द पब्लिक अकाउंट कमेटी. द अप्रोप्रिएशन अकाउंट कंपेयर द एक्चुअल एक्सपेंडिचर विद द एक्सपेंडिचर सैंक्शन बाय द पार्लियामेंट. इज इट राइट और नॉट? दैट इज द work of the CAG. While the finance account shows the actual recipient, it means the finance amount is the actual annual recipient receipt in the form of the revenue disbursement of the union government. Okay, third में यहाँ पे नहीं दे रखा. Anyway, let us discuss the next question of today. I think that is the last question or the last second question. Consider the following statement regarding इंदिरा साहनी केस है. Okay, इंदिरा साहनी केस है, सुप्रीम कोर्ट है. आर्टिकल 16 से रिलेट करते हैं. नागराज केसेस. What is it? It is the just a type of reservation of whom we can give, we cannot give. What type of criteria that should be taken care of. What type of the backwardness we are taken care of to giving the any of the reservation to the parliament, to the people of India. And number second, what is the limit on the center, limit on the state, and what type of the cases that are can include in the schedule 9 or not. That also be the case of the related the Indira Sahani and the Nagaraj cases. And one more thing is there, the caste or whatever be the community that is the case for the reservation, that should not be economically back, socially and educationally backward criteria is taken care of in case of the many of the reservation that already taken, but economically is newly added. That the I think what article 102 constitution amendment bill. Let us see the question. Indira Sahani case you have to know, and you are reading the article 15 or the 16 in itself. Yes, one information about the article 15. Article 15 is the just recognition of the reservation. It means it does not define the reservation itself. It gives the power to the parliament in which he or she or the parliament can make the law, and under article 16 make the laws by the parliament and enacted the parliament as per the article 16. It just the conferred the power to the parliament. Let us see the question that you can very much define. हम बहुत कुछ डिस्कस कर चुके हैं. इन इंदिरा साहनी केस यूनियन ऑफ इंडिया एंड सुप्रीम कोर्ट हैड दैट रिजर्वेशन अंडर आर्टिकल 16 clause 4 yes 16 clause 4 yes could only be provided in the time of the entry into government service but not in the matter of promotion. Is it right? Number second, in नागराज केस, इन द सहानी केस कब आया था एंड सुप्रीम कोर्ट ने कहा कब कहा? यू कैन इमेजिन द थिंग. इन नागराज केस द सुप्रीम कोर्ट से दैट द स्टेट इज बाउंड टू मेक रिजर्वेशन फॉर द एससी एंड एसटी. इज इट नॉट? आई थिंक मेरे हिसाब से दोनों के दोनों ही गलत हैं. ओके, ही इज राइट. How it be? In Indira Sahani case, Union of India, the Supreme Court held a reservation under Article 16 clause only provided the time of entry but not the promotion. Yes, that is right. And in Nagaraj case, the Supreme Court, but ये Nagaraj case नहीं है. I think so. मुझे ये पहले का केस है. And Nagaraj case, the Supreme Court has the power to no, not at all. तो यहाँ पे A सही है. Yes, I found the answer here. In landmark judgment of 1992 decision in Indira Sahani versus Union of India, Supreme Court held that the reservation under Article 16 clause 4 could only be provided at the time of the entry of the government, not the matter of the promotion. It is added that the principle could operate only on promotely and not promotion already made at the reservation already provided in a promotion shall not continue operation for the period of 5 years from the date of the judgment. It also that the creamy layer can be and must be excluded for the SC and ST specifically. Can be and must be excluded. On June 17, 1995, Parliament acting its constituent capacity adopted the 77th Constitution Amendment. It means 77, by the which clause 4A was inserted in Article 16 to enable reservation to be made in promotion for the SC and ST. The validity of the 77th and the 89th 85th Constitution of the Constitution and of the legislature enacting the pursuance of those amendment was challenged before the Supreme Court in the Nagaraj cases, upholding the validity of the Article 16 that added in the 77th Constitution. And in Article 16 Clause 4A, the court said that the enabling provision, the state is not bound to make reservation for ST and ST promotion, but if it seeks to do so, it must collect quantified data on three factors. Number first is the backwardness of that class, number second, inadequacy of the representation of that class in public employment, number third, general efficiency should not be compromised as per the Article 335 that is given in the DPSP, that is the outside of the part 4 of the Constitution. Right, I think you can understand here that can be challenged in, but that should be some condition that are taken care of, that is the backwardness, number second efficiency, and number third is the representation of the class, and the general efficiency and the inadequacy of the backwardness that are present in that service. It means that the indirectly नागराज केस जो है प्रमोट करता है कि रिजर्वेशन इन promotion of the SC and ST can be given, but that three conditions should be met. Number first, the efficiency should not be undertaken care of. Number second, the inadequacy of the backwardness that represented in that service. Number third, representation of the class. Number four, general efficiency should not be affected. Next question is about the election commission. We already discussed the election commission of very much. Election commission under Article 124 of the Constitution, that is the reservoir of the power 124 under the part 4 of the Constitution. And what type of power is given to the election commission? Let us see. Number first, he should be a citizen of India. उनकी कोई भी क्या क्वालिफिकेशन होनी चाहिए, किस तरीके से उनको हटाना है, that should not be given. But yes, the general perception is that he should not. Just a minute. Let's discuss the Article 324 in context of the इलेक्शन कमीशन. मैंने आपको शायद 124 बताया. आई एम रियली सॉरी, इट इज फॉर द सुप्रीम कोर्ट, नॉट फॉर द इलेक्शन कमीशन ऑफ इंडिया. आर्टिकल 324 द कॉन्स्टिट्यूशन हैव मेड द फॉलोइंग प्रोविजन रिगार्डिंग द इलेक्शन कमीशन. बिकॉज मुझे भी कन्फ्यूजन, तो मुझे इस वजह से बुक की हेल्प लेनी पड़ी. द चीफ इलेक्शन कमीशन इज प्रोवाइडेड विद द सिक्योरिटी ऑफ टेन्योर, विच मीन्स दैट हैज द सिक्योरिटी ऑफ टेन्योर. ही कैन नॉट बी रिमूव्ड फ्रॉम द ऑफिस एक्सेप्ट इन द सेम मैनर एंड ऑन द सेम ग्राउंड. It is written in the Constitution itself, the same ground as a judge of the Supreme Court, but is not like the other two members of the simple election commissioner. In other words, he can be removed by the president on the basis of the resolution passed to that of the both houses of the parliament with a special majority either on the house of the private misbehavior or incapacity. Thus, it does not hold office till the pleasure of the president, so that it has the independent in nature. Next is the service condition of the chief election commissioner cannot be varied to disadvantage. It means that it should not be given disadvantage position, and its salary could not be reduced. Any other provision, and its salary if reduced, that not reduced, if increased, that is the mandate of the parliament. And I think it is an article schedule set forth. Let us see in after that thing. Any other election commissioner or a regional RDO cannot be removed from office except on the recommendation of the chief election commissioner. It means that some security of the provision is given to the election commissioner at the regional election commissioner. Though the Constitution has sought to safeguard and ensure the independence and impartiality of the election commission, some cannot be noted, some can be, or cannot be noted. Note first, the Constitution has not prescribed, do remember, not prescribed the qualification, legal, administrative or judicial of the member of the election commission. It means that it has not prescribed any qualification, but it ensures the independence of the election commission. Number second, the Constitution has not specified any term the member of the election commission. Number third, the Constitution has not debarred the retiring election commission from any other further appointment by the government. It means that it can be appointed further. Constitution does not debar it. Power and function, okay, administrative advisory है, quasi judicial है, to determine the territory area of the electoral jurisdiction throughout the country on the basis of the Delimitation Commission Act of Parliament. Number second, to promote and periodically revise electoral roles, that is the duty of the election commission. To notify the dates and schedule of the election. Number 4, grant recognition to the political party, that is related to the election symbol, allocation of the symbol to them. To act as a court of the setting dispute related to the granting of the recognition. Number 4, to appoint the office of 2 for inquiring into dispute relating to the electoral arrangement. To inquire the code of conduct to be observed by the parties and candidate at the time of the election. Number 8, TV वगैरह पे जो इलेक्शन वगैरह का थोड़ा सा मोड ऑफ कंडक्ट को भी यहाँ पे दिया गया है. That is the working there. And not going to. What is the vision? What is the mission? And what is the simple guidelines? You can see here. Note. Let us discuss the 10th question. We already see the election commission. Election commission can disqualify candidate who commit electoral malpractice. Is it the power of the election commission? Number second, जो constitution empower the election commission to decide whether candidate has incurred disqualification by holding any profit of office. दोनों की दोनों spaced. Which of the following are correct? Correct is second. The Constitution empowers the Election Commission whether a candidate has incurred disqualification on the because it has a special provision of the member of parliament whether they have the to continue office of profit or not. Whatever the limitation of the Election Commission power, Election Commission does not have the power to disqualify candidate who commit electoral malpractice. It does not have the power to disqualify candidate who commit electoral practices. At best, it may direct the registration of a case only. इट मीन दैट येस कैंडिडेट के रिगार्डिंग कोई ज़्यादा खास पावर नहीं इलेक्शन कमीशन के पास डिस्क्वालीफाई करने की. डेट इज द प्रॉब्लम इन विच द इलेक्शन कमीशन आर सफरिंग. नंबर सेकंड, द इलेक्शन कमीशन डज नॉट हैव द पावर टू डी रजिस्टर एनी पॉलिटिकल पार्टी. However, the Constitution empowers the election committee to decide whether candidate has incurred disqualification by holding an profit of office under the appropriation of the government or under the declared and insolvent or acquired the citizen of a foreign state. It means it does not deregister any political party. I think it has a question, right? I don't know is it statement is right. Anyway, when a question arises whether a candidate has incurred any of these disqualification, the President of India or Governor has to refer to the Election Commission. The poll panel decision on this is binding. I think ये गलत है. देखते हैं, let us see. और इसी के साथ हमारे